I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended.
Welcome back to another courtroom breakdown. Today, we look at a defendant trying to use jurisdictional arguments to get out of a suspended license charge. Let's see how the judge handles this complex web of excuses.
So we've got two DWS files, correct?
Over another who's in board status, but I think we're here on this motion hearing.
Yeah, so one file's a money issue, the old one from December 2016. That's a drove while license suspended. The file shows you owe money.
Yes.
Right, all right. So we'll talk about that one. All right, and then you filed a motion on the case from November of 2025, correct? All right, give me a minute to look at the paperwork. Okay, I did see Mr. Blade's motion. I did have a chance to see that, read that one already. So I'm going to read the people's response. Okay, I've had a chance to review. So anything you want to add to your written brief?
It's showing that there was no personal jurisdiction in the court back the authority to make a judgment or default judgment.
You're talking about the Monroe case?
Yeah.
Okay, go ahead.
They lack jurisdiction in order to make that case or make a judgment for.
Anything else?
I can't find them easily to prove service and collective. I saw people service from the
You're, just to be clear for the record, we're still talking about the Monroe case?
Yes.
Okay, go ahead. Right, right.
To ask for proof of service that were unable to provide it.
Right.
They told me that it was for the sheriff. So I went over to the sheriff's office to ask for proof of service because that service.
Right.
Because I didn't receive the notice to appear in court, so I had no idea that we were charged with it again.
Okay.
And going forward, I go to the sheriff's office. I ask for the proof of service from the sheriff's secretary. I'm not sure that they were the position or if she said behind the test. But she noticed that the ticket had the officer's name, which happened to be down currently the tenant. He come out and spoke to me. He said, I don't remember this ticket. I don't even believe I was, I don't even believe I was on that shift at this time. A few things that he mentioned to me. So I wasn't prepared for this. I was studying everything supposed to be correct. When he spoke to me, I took what he said and I said, okay, maybe I can get him to fill out an affidavit.
Right.
The things he said, I'm not asking him for anything in my favor, just what you recall, all I want. He didn't respond in time. He mentioned that he would have no problem speaking to the court here for the last case. But I didn't receive that response to the court. He went to my motion. The officer said he believes that I did have insurance, but I was put show force. I didn't know the case was the court to be there. It's prison charge.
Okay. Anything else? Anything to add to your written response that I just read?
The court is well aware that this court doesn't have any jurisdiction over a no proof of insurance citation that was issued by Monroe County Sheriff's Department in 2005.
All right. Mr. Blade, I've got a question for you. Do you know whether or not the Michigan Secretary of State listed you as a valid driver on November 29, 2025?
No, I have no idea.
Okay. So if if I told you the Secretary of State record showed you were suspended on the day that Officer Hayden stopped you, you would have no reason to take issue with that fact? If I told you that your driving record listed you as a suspended driver on November 29, 2025, you have no argument one way or the other whether or not that's the case.
One more time.
If, no, that's all right. I don't want an answer if you don't understand the question. If I told you your Secretary of State driving record showed you as a suspended driver on November 25th of 25, would you have any reason to deny that as factually correct? Okay. All right. So I'm going to deny your motion for two reasons. Number one, his actions are based on what the Secretary of State says, not what the Monroe County Sheriff's Office says. B, I don't have the authority to do what you're asking me to do, because if I understand the situation, your Monroe case has been completely adjudicated in Monroe. They've left that on your record. I don't have the authority to change that record.
That's not what my motion is asking. I'm only asking you to recognize the jurisdiction. That's all I'm asking.
I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So my ticket, the Huron Township ticket, is a perfectly valid ticket moving forward.
But the jury,
Gather your thoughts. I'm not in any hurry. These kids want a show.
default judgment issued without prior notice can be deemed as a violation of the party's right to due process.
Absolutely. Absolutely. But not by me. I can't override the Monroe Court. Now, I can take all this into consideration when I sentence you on this file, but I can't set aside what happened in Monroe. Okay. Okay. Are you just seeking to mitigate your damages here? Are you just seeking to mitigate your damages in this court based on what happened in Monroe?
Monroe is the reason I'm here. So
Absolutely.
we can't separate the two because it's the Monroe charge that got me of driving without.
Right.
That got my life.
Right. I understand that.
I did insurance, which I absolutely did. Would you like to see that?
No. I'll for today's argument, I'll take your word for it.
I did actually have insurance,
Right.
but I didn't have an opportunity to defend, to show the court that I had insurance. So going to jail and then to prison right behind us, when I come home, I'm trying to get my life together.
Okay. Well, first of all, I can't speak from personal knowledge of Monroe, but every court I know of on a civil infraction, they don't send a notice out on the civil infraction. The ticket is your notice that you've got a problem you got to deal with.
But I didn't receive it. I went to jail that night.
So they never handed you a ticket.
No.
Okay. Well, then you got a problem, but I can't fix it. I don't have the authority to fix it. If we have a trial on today's DWLS case, as prosecutor, she's going to have to prove to me that on November 29, 2025, your driving privileges were suspended in the state of Michigan. And she's going to have to prove to me that you were driving a vehicle on that date in Huron Township. If she proves that to me, I'm finding you guilty of drove while license suspended, revoked, or denied. The fact that the Secretary of State shouldn't have suspended you does not change that at all. You were suspended. Whether or not Monroe screwed up or they didn't screw up, you were suspended. So I'm denying your motion. Okay? I'm assuming we can have some pretrial conversation.
And you're,
Okay.
like, if one wishes to plead to be drove while license suspended, I will dismiss the two remaining.
And I don't even have the remaining charges, so are they already in default? Or did I just not get the files?
Vehicle and another misdemeanor registration title among the police.
Oh, I'm sorry. I was looking for civil infraction. Okay. All right. Do you want to avail yourself of that offer? He will dismiss 2 misdemeanors if you plead to the drove while license suspended. So the misdemeanor unregistered vehicle and the plate or registration violation misdemeanor, right, those 2, would be dismissed if you plead to the drove while license suspended, revoked, or denied.
Think that over.
The hallway is yours. Yeah, go take a minute. That's fine. Why?
Research.
You no objection to another? We'll adjourn it. Oh, I don't care. March 12th, give you enough time?
Yes.
Okay, so Heather will prepare a notice on that one. Now, as to the December 1, 2016 file, our records show that you owe $840. Are you in a position to make some kind of a payment plan on that?
But I have any money to pay. I currently don't have any money.
All right, you're confused. You don't have any money today?
Yes.
All right, but you could commit to some regular payments and make them. How much, how often, when do you want to start?
I think about financial. But I don't make very much money.
I need you to make some kind of commitment today if you can. You don't have to start it today.
It shows that
Okay. How much?
even if it's just one number.
No, I'm not paying a clerk to process a dollar payment. But I got to get something going. How's this? When's the last time you worked? Where do you work? Walmart? Cormart, what do they do? Okay, full-time job? Okay, can you pay $50 a month? Start when? First Friday of March is the 6th, and that's 2 weeks out. Can you do that? 50 a month. We'll always take more, so if you want to pay extra, $50 a month, starting March 6th. Yes? Agreed? Okay, we're getting you notice on that other court date. Have a good day.
Yeah.
You're welcome. Officer Haydack, always a pleasure. Be safe.
In this intense courtroom exchange, we witness a classic confrontation where a defendant attempts to argue against the court's jurisdiction, a common tactic often seen in sovereign citizen cases. However, the judge remains completely unfazed and meticulously dismantles the argument with unyielding logic and legal precision. The defendant claims that an old ticket from a different county was handled improperly, leading to a suspension he believes is entirely invalid. He argues that because the previous jurisdiction allegedly violated his due process rights when he was unaware of the charges due to his incarceration, his current charge of driving with a suspended license should simply be thrown out. But the law doesn't work that way, and the judge makes it absolutely clear. He explains that his courtroom only has the authority to deal with the facts of the current traffic stop. The indisputable fact remains, on the day the officer pulled the defendant over, his driving privileges were officially suspended by the Secretary of State. Whether that suspension was born out of a clerical error, a miscommunication, or a genuine mistake by another court is completely irrelevant to the current charge at hand. The judge brilliantly articulates that he does not have the magical authority to reach across county lines and erase a finalized adjudication from another jurisdiction. His job is to rule on whether the defendant drove while his record showed a suspended status, which he undeniably did. This scenario perfectly highlights the strict boundaries of legal jurisdiction and the harsh reality of administrative records. It serves as a stark reminder that ignoring the bureaucratic nature of the justice system leads to further legal trouble. If you want to see more incredible courtroom breakdowns, make sure to subscribe to Law Reality and hit the notification bell to never miss updates.